I'm not going to do a lot of editing. I'll try to boost the sound, but beyond that, I'm not going to spend hours and hours doing editing. So I'll apologize in advance.
Good morning. First and foremost, on behalf of myself, my colleagues, Gene here and Guillermo, I would like to thank you for your time and for your attention. And I noticed a lot of you guys were taking notes, and I appreciate that. I know it's been a long process, but I appreciate you guys hanging in there with us. I told you in opening statement, we'd be presenting 40 witnesses to you, and I think we had about 38. And in the opening statement, I gave you an outline of where I was going. And that's what I want to talk about right here. Now, in the opening statement, the defense called the defendant, Kaitlin Armstrong, a shrinking violet. Not me. I don't call names. They called her a shrinking violet. Now, paragraph 12 in your charge talks about all the evidence that comes from here. This is your shrinking violet. This is what the evidence showed you who she really is. January 12th, 4 months before Mo Wilson was killed and taken from us.
Oh, she's at the
Now,
shooting range.
I also told you in opening statements, and I used my hands, that the last thing that Mo Wilson did on this earth on May 11th, 2022 at 9:15 p.m. was scream in terror. And that evidence came from Mr. Donald's audio from his camera, G4 camera, from this witness stand. I was true to my word. I brought that evidence to you. And I also told you on that tape, heard 2 shots. And there was a 4 or 5 second pause. I told you in opening, and I presented it to you pursuant to paragraph 12, evidence from the witness.
You can't unhear that. The first 2 shots were in rapid succession with bang, bang. And the evidence is that the trajectory of the shot was on a downward angle. Also, that she had defensive wounds. If somebody had come in and presented a gun immediately, she might not physically try to attack. She might scream. She would do this, and that explains the injury to her hand. Anyway, those first 2 shots sound to me like somebody, reacting. She screams and they react. They got to shut her up. I don't imagine if it was Kaitlin, it's not like there was going to be a big conversation or argument or anything beforehand. Mo would not have let her in. So I'm curious about the defensive wounds. The next shot was several seconds later. It makes you wonder if the perpetrator didn't, come in thinking that she or he would use the gun to get something, to threaten, to scare, to argue, and then had to shoot her to shut her up. And then once that was done, look at her on the floor and think, man, I can't, I have to finish it, right? I mean, that's a possibility.
Stand that she stood over her. This young lady over here, the defendant Kaitlin Armstrong, I told her she stood over her after she shot her in the head twice and put another bullet right in her heart. You heard Dr. DeRusso, the ME. That third bullet was right in her heart. And She also testified.
This is smart. You see on the display, he's talking about the evidence. He's talking about what happened. There was silence after the shots. And then, instead of saying there was another shot, he puts Kaitlin's name on the display. Kaitlin put another bullet right in Mo Wilson's heart. He is definitely attaching that name, her name. It's not abstract evidence. This is this accused did this thing to this victim. So it's sort of mentally connected. It's not just abstract evidence on paper. I'm not sure if I just made sense.
That because of the exit wound, she was up against something.
The floor.
I submit to you, she was up against the floor.
Yeah.
2 to the head, and she was laying on the floor, probably already dead. And for good measure, the defendant walked up to her and put another bullet right in her heart.
Mm-hmm.
And I also told you that 19 days before this trial, she escaped from the sheriff's department. Now, I'm going to tell you the irony of this. We picked this jury on October 30th. We started our evidence on November the 1st, Dia de los Muertos, the Day of the Dead, November the 1st. It's a day that the Mexican-American culture celebrate those who have gone before them. We started this evidence on the Day of the Dead. So you see from this video here, you see her? She's not just running from the sheriff's department. No, sir. That's 19 days before this trial. She's running from you, and 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 she's running from all of you on the back row. Because you are a jury of her peers. Everybody deserves their day in court. And she got hers. And you can see from this video,
this prosecutor is smart. He understands the psychology.
didn't want to face you. Now, the offense charge in this case is murder. We're going to go over this really quick because it's in your charge. Murder. These are the elements that we have to prove to you. That the defendant intentionally or knowingly caused the death of an individual or intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. Two ways to commit it. A person's intentionally or knowingly cause the death of an individual. Intentionally. It gives you a definition. A person acts intentionally or with intent with respect to a result of her conduct when it is her conscious objective to cause the result. Or you can go on the second part, which is knowingly. A person acts knowingly or with knowledge with respect to a result of her conduct when she is aware that her conduct is reasonably certain to cause the result. It even defines an individual. Individual means a human being who is alive. It defines serious bodily injury. Bodily injury that causes a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss. And it even defines a firearm. A firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. Now, unanimity. What that means is this. You need to be unanimous that the defendant committed murder. You do not need to be unanimous on what theory you use if, for some reason, you don't have the same theory. Some can believe that it was intentional, some can believe that it's knowingly, and some can believe that she just committed an act clearly dangerous to human life. as long as you all believe that the defendant on May 11th caused the death of Anna Mariah Wilson. So, this is what the state has to prove, right here. On or about May 11th. I think we're getting a lot of evidence about what day it happened. In Travis County, Texas. We talked about through the detective that this happened in Travis County. That the defendant, Kaitlin Armstrong, intentionally or knowingly caused the death of Anna Mariah Wilson or intended to cause serious bodily injury and committed an act clearly dangerous to human life that caused the death of Anna Mariah Wilson with the firearm. I believe the state has met that burden. I think we've proved all them elements, and I believe we have proven beyond a reasonable doubt. So, if you remember...
That's clever. He's focusing on the elements of the crime, which are clearly there. I mean, nobody can deny that. A toddler could not deny that those elements have all been met. And he is then, with that certainty, tying it to the accused and saying, and she's the one. So they've already got in their head, they're going through this checklist thinking, yep, he's met the onus for all those elements. And the last thing to tie in is the accused, and he's doing really well.
Doing an opening statement, the defense showed you a little mountain we had to climb. I'll submit to you that pursuant to paragraph 12, through those 40 witnesses, we climbed this mountain. Never seen so much evidence in my life against one person. Now, the purpose of this is to relate to Steve Aston, the ballistics tool mark expert, who, by the way, testified that he's never had issue with proficiency tests. And they asked him 3 different times. So you never made a mistake? No. So you never made a mistake? No. So you never made a mistake? No. Now, if you allege that he made a mistake, guess what? Pursuant to paragraph 12, no evidence that he made a mistake came from that witness chair. In fact, you heard 3 hours of testimony from Mr. Tobin. And at the end of 3.5 hours, he said, and I quote from Mr. Gonzalez, "No, I'm not here to contest his findings." That's 4 hours of our life we'll never get back. That's it, not my words. It may be funny, but those are his words. I'm not here to contest his finding or to say that it's not a match.
Wow, he is so good. He's using the defense's own graphic against them. He's using the defense's own witness against them.
Now, they asked Steve Aston several times, why did you not exclude all other guns in the world? No one else in the world had a 6-hour P365 and left their DNA at the scene. Nobody else in the world fit that description. No one else in the world was angry that their boyfriend was out with Mo Wilson. Just her. No one else in the world had their Jeep circling 1708B Maple for an hour before you heard that 915 shot. No one else in the world matched that description.
No one else in the world. And then he puts forth things that are true. So no one else in the world was jealous of their boyfriend being with Mo Wilson, as an example. What he's not saying is, or what he's not addressing, is anything that the defense might bring any alternate theories so he can stand there and be telling the truth and make it sound like this is the only possibility when it could be arguable that it's not. He's very, very good. He knows how to present things, and he knows how to get their emotions going, and he knows how to take them down this line of reasoning that where it would be easy to sort of forget about anything else.
Dude, when you got nothing, you pick on the detective and you talk to him about where you didn't look.
Yeah.
The amount of evidence that we have, we try to distract you from that. And finally, no one else in the world left the scene of the murder in Kaitlin Armstrong's Jeep that was parked in that alley from 8:40 p.m., 2 minutes after the murder. We don't need no one else in the world to make these facts that came from that chair true. These are not my words. These are facts that came from the witness chair. No one else in the world fits this criteria. So that, did you check every gun in the world? That's called a rabbit hole they want you to go down. Only Kaitlin Armstrong, the defendant, fits these facts that was presented to you through that witness chair. Now, let's talk about her best friends, one of them. One of them says she's a friend, one of them says she's a best friend. She told Jacqueline Chastain about the gun a month after it was purchased. Nicole Mertz said, I've never seen her that upset before, and that's why I remember. Never seen her that upset before. These are her friends. We called them, but they were her friends. You heard them. Don't let anybody recharacterize a relationship. Those two ladies got on the stands and said, we are her friends, and one of them said, she's my best friend. And we know Kaitlin called Mo Wilson to confront her about Kate. We know that from the cell phone records. We don't know exactly what she said.
Of course she was upset. Of course she was angry. And this was back in October. Doesn't mean she wasn't angry in May. Doesn't mean she was.
So I'm not going to put that out there. But we know she called her. And we know Colin texted her and said, WTF. And we all know what that means. And what's even more chilling is that when the defendant's two best friends heard that Mo Wilson was dead, they called the police unsolicited. And they said, better check her out. Better look at her. Now, they both testified that, no, I didn't take that serious in January. But then when they backed up and put it together about how angry she was, about her shaking to the point where she has never seen that angry before. If anybody knows you, your best friend knows you.
That answers my earlier question about why does this person need to remain anonymous? And this is a good explanation. If you thought your best friend did something or your family member, you wouldn't want to be giving your name. It would be really hard to call the police.
That he's not our best friend. But guess what? Did anybody sit right here and contradict Chastain and Mertz's testimony that they were her friend and her best friend? No. So that's the evidence that you have to work with. Her best friend called the police on her. Now let's talk about these surveillance videos. You heard a lot of talk about the surveillance videos didn't cover the stairs to Cash's house. No. Generally, people have surveillance cameras to protect their own property. The lady in the alley, she had a camera in the front and the back of her house. camera wasn't to figure out who might go up Cash's stairs and kill her best friend, Mo Wilson. Her camera was for her own protection. It was on 18th Street, north. And to the east, on Maple, there was a couple of cameras. And those cameras point to the front of those people's house and their porches for their protection, not in the alley. Once again, they want you to look somewhere where the evidence is not. And when she left, you didn't see the Jeep. The reason you didn't see the Jeep is she left south in the alley. The camera was north and east. Remember further north, the camera caught the motorcycle going by? There was no camera. Now, I'm not suggesting that she knew that at all. I don't believe she did. Because if she did, I don't believe she'd been circling in that Jeep that whole time. But no, a camera didn't catch her leaving. The GPS, that Jeep put her there. Now, let's talk about this black Jeep. Remember initially when the 3 or 4 video people came up here? And I want you to split your mind down the middle. On the left side, all this noise I'm talking up here, they're going to be talking. On the right side, I want you to think about section 12 of your charge, what came from this witness statement. Now, initially, when those video people came about, you remember the cross-examination? Do you know how many black Jeeps in Austin? Do you know how many black Jeeps in the neighborhood? How do you know it's that black Jeep? How do you know it's a Jeep? Aren't there a lot of black SUVs? Well, the minute Daniel Portnoy comes up and takes that GPS out of her Jeep, and we see her at CarMax in her Jeep, now they switch gears to how do you know she was driving her Jeep? You see the
Yeah, that was a weak argument. It would be different if they claimed, or if the defense claimed and they didn't, that a very specific person was driving the Jeep, but they didn't. I think it's pretty clear that it was her Jeep. That was another question I had in the very beginning of this. How do they know it was really hers? Well, they know.
Rabbit holes, they're going to try to send you down. First, it wasn't her Jeep. Then we got proof that it was her Jeep. And now she wasn't driving the Jeep. Now, I want you to look at your picture on the screen and think about one thing. At 9:17, track 100 of that Jeep, 2 minutes after that murder, just a few feet down that alley. Track 100 starts at 9:17. Now, this is not a true picture of 9:55 p.m. that night. I just wanted to show you this because you see Colin Strickland in that garage right there? That's exactly where he said he was at 9:55 p.m. or somewhere around that time when Kaitlin Armstrong, the defendant, drove up from murdering Mo Wilson in that black Jeep. The same black Jeep that from our first 10 witnesses wasn't a black Jeep, wasn't her Jeep. And then the second set of witnesses, she wasn't in the Jeep. That same black Jeep that she was not in, drove up. And like Colin testified, he was in the driveway with the garage up when she showed up at 9:55. That takes away all these phantom people. You remember all that talk about how many people went to the house for this, that, and the other? Rabbit holes. Go back to section 12, this chair. Did you give any testimony that anybody was driving that black Jeep, her black Jeep, with her phone? Now, Ms. Mazak, who did a wonderful job. All those text messages, all those things. They came back and made her say, Kaitlin's phone, not Kaitlin with her phone. To imply that someone may have stolen her Jeep, stolen her phone, and the geolocation put them in the same place.
And then gave it
Whoever
back.
stole her Jeep and stole her phone, they was running side by side. But check this out. Whoever stole her phone and was in her Jeep sent somebody a text message with her home address from that phone that they stole that was not in her possession, if you believe that.
Yeah.
And that same person who had Kaitlin Armstrong, the defendant's phone, sent Colin Strickland a text message about a lawsuit that they had going on with some real estate issues. So if she didn't have her phone, whoever stole her Jeep and her phone was also interested in her lawsuit and where she lived, if you believe it.
In fairness, that was sent long before 720 even, but he's right. I mean, somebody stole her Jeep and her phone and committed a crime and then gave her Jeep and her phone back. It's ridiculous.
And there's no evidence to suggest that it was anybody other than her. And finally, that same phone says she had to run errands earlier, and she texted Colin saying "Eeny," which I think means finished.
20
So
after
whoever had her phone,
7.
it wasn't her. They were finished running their errands just like she was. See, the more I talk, the more ridiculous it gets. That it wasn't her with that Jeep and that phone. Now, they talked about Pam Mazak, that GPS, they asked her 3 or 4 times, is GPS more accurate than CDR data? She said yes. Now, remember when Portnoy was there, they kept talking about how GPS wasn't that accurate. 2 days later, Mazak get there. Now, GPS is more accurate than CDR, isn't it? We agree, it's accurate, because it puts her Jeep at the scene, puts it at 8:40, has it leaving about 9:17, and has it driving up at her home at 9:50. Her Jeep, her GPS, pulled out of her car at CarMax. And the DNA on the bike puts her at the scene. Proof that Kaitlin was there when Mo Wilson was shot. Gunshots at 9:15. Jeep parked in the alley, leaves after the gunshots. Caitlin's DNA on the bike. Shell casings that matched the gun. And like Detective Ramirez said, it was personal. So she shot her in the heart as she's all on the ground based on the exit of that bullet. Now, when the defense expert got up there, he said 3 times, and I'm like, whoa. DNA tells us who was there. I agree. That's their expert, not ours. Our expert was more cautious talking about the ratio. He said DNA tells us who was there. And I agree. She was there. We'll go to this evidence real quickly. The video evidence shows us that Kaitlin was circling 17.
There is transfer DNA, there is cross-contamination. It is possible for you to have your DNA somewhere where you never were. So if you live with somebody, your DNA can be on them. You could have handled something that somebody then takes away and it ends up somewhere else. So it depends. But this is clever.
8, maybe about an hour. Shows us her Jeep in the alley 1 minute before Mo unlocked the door. Cell phone corroborates the GPS. Has all those personal messages. DNA evidence, Dr. Caliphate talks about tertiary and quaternary or whatever that 4th level is transfer, never seen it. And the evidence from Samantha Perkins that it's 224 billion times more likely that the DNA included Kaitlin Armstrong as opposed to somebody else. Now, you've heard a lot of testimony about that.
Lawyers will say, or people advocating will say, oh, but they only say strong possibility. Well, that number he just gave you, an expert will say, well, that means there's a strong possibility. What's the population of the world? right? Compare the number with the population of the world. It's her DNA.
The third profile could have been anybody. Could have been a mechanic, could have been an airport person. It could have been anybody's DNA. So don't let them go down that rabbit hole, and that's the real killer, some kind of grassy knoll theory. That third person DNA, it doesn't explain Kaitlin Armstrong's DNA on that bike. That's what it doesn't, unless you took somebody with it. So don't go down the rabbit hole, because there's no evidence that any third person did that. And look at all the other evidence and just use your common sense. Steve Aston, very confident that Kaitlin Armstrong 6-hour P365 is the gun that killed Mo Wilson. And the GPS has us circling for an hour before, tracks her the whole time. Undisputed from the witness stand. I've talked about this. You didn't see her exit route because she went a different way than where the cameras was. Mid-South. This was a race that she had just won, one of her recent races. Mo Wilson is a 25-year-old prodigy. Everybody in the cycling community that testified kind of shook their head about how good she was, and she was new at it. A prodigy. Taken from Matt and Mr. and Miss Wilson at the age of 25. Kaitlin Cash over there on the front row. When I talked to her, call me Cash. Kaitlin killed my friend. That's why we call her Cash. Kaitlin with a C. Poor thing don't even like her own name anymore. She pumped her friend's heart over 100 times. You heard it on the 911 call. For 10 minutes until the first responders got there. Not knowing she'd probably been dead for 45 minutes. Then she runs to Costa Rica, had plastic surgery, on the beach teaching yoga while the Wilsons are trying to pick up the pieces. The state has met its burden of proof beyond a reasonable doubt. I think we climbed past their mountain and climbed Mount Everest. Overwhelming. Now, I'm about to get up here and send you down a bunch of rabbit holes. I ask you to do me one favor. Tools of a prodigy. She's about to set the world on fire. So don't do me a favor. Do Mo Wilson a favor. And I got one last thing to say to you. Get your notepad. Write a line down the middle of it. If you don't have a notepad, use a notepad in your brain. And when they get up here, do something for me, but do it for Mo. When they say something and singing out a rabbit hole, write it on the left side. If it's proven from the evidence chair, pursuant to paragraph 12 of your charge, write it on the right side of your paper. And we've been here a long time, but we ain't got to stay much longer, because when you get to the back, I submit you that when you separate the left side of the paper from the right side of the paper, it's going to be blank, and we can get out here pretty quickly and find her guilty of shooting Mo Wilson in the heart and in the head and taking away this prodigy at the age of 25. Don't think about closure. Don't think about none of that. Don't think about the community. That's not your burden. Your burden is to follow the law. I only ask you to do one thing. Justice for Mo Wilson, the state has met its burden. I'm asking you to find her guilty. And don't let her run like she'll have to do 19 days before this trial. Thank you.
Kaitlin's cooked. This guy is good. The conclusions that he's putting forth are reasonable conclusions. The big question is whether or not the defense has or can, in their closing statements, introduce reasonable doubt. We're going to see in a second. This guy, I just want to comment, this guy is so good. He's so smart. I wish that I had a mentor like this when I was young and just starting out. He knows how to construct the story, even down to making them laugh at one point. He knows how to reach in and connect with the people of the jury based on the opening statements. And I don't know what's going to happen here, but based on the opening statements, the defense wasn't connecting with them. I think this prosecutor could convict about just about anybody. I think he's really good.
The state bears the burden of proof. And so the district attorney speaks first in opening and closing argument, and then they speak last. My name is Mr. Kofor. It's been a privilege to represent Kaitlin Armstrong. I'll visit with you a little bit, and then my colleague, Mr. Purrier, will visit with you. When we sit down, Mr. Gonzalez will have the opportunity to speak with you. 1 year, 4 months, and 12 days. That is how long Kaitlin Armstrong has asserted her innocence. And from day one, she asked for this trial. She asked for you to hear this case.
Except when she was running away.
You've all done extraordinary work. This is a difficult case. It is an emotional case. It could appear to be an easy case. For those 1 year, 4 months, and 12 days, Kaitlin Armstrong has been trapped in a nightmare of circumstantial evidence. How do you go about disproving a negative? The government has presented you the government's case to meet the government's verdict. There is a lot of sizzle. There's not much stake. It's a case based on assumptions, it's based on confirmation bias, and a lack of direct evidence. Let us talk about the case.
He has a point about the confirmation bias. Right from the get-go with the detectives, there was confirmation bias. There's no question about that. Now, whether that confirmation bias changed anything substantive, whether or not that confirmation bias means that the opposite is true is a separate question altogether. But there was confirmation bias.
Against Kaitlin Armstrong. It starts with jealousy. Jealousy is suspicion of someone's unfaithfulness in a relationship. And jealousy is a type of insecurity. We know that Colin Strickland fostered insecurity, and he has become the new poster child for Peter Pan syndrome in Austin, Texas. So what is the evidence that Kaitlin Armstrong is a jealous psycho? Colin was not honest with Kaitlin about his special friend in Colorado. And Kaitlin allegedly sent him a photograph of that friend. The implication being, number one, perhaps she'd been looking at his phone, and number two, that she's crazy and jealous because when he was sneaking off to Colorado to meet up with the person and sending him inappropriate photographs, she had the temerity to not like it. Kaitlin called Mariah Wilson once in October 2021. The text messages introduced into evidence show you that she had immediately before been in conversation through those messages with Colin about the location of her helmet. Probably it wasn't a phone call about that. Let's be real. Probably it was a phone call, something to the extent of, by the by, Colin Strickland is a little bit of an ass, and I live with him. Is that so unreasonable? Is that insane? Kaitlin also had the chutzpah.
Just want to pause for a second. He talked about Colin fostering the insecurity and actually fostering the jealousy. I think that is true. I mean, you see it from the things that he said to police, things he said himself. Somebody in my comments pointed me to a New Yorker article about him in 2022. And if I remember, I'll link it in the comments. If I don't, somebody remind me. In that article, somebody who knew him said exactly this. I mean, he's displayed a pattern of behavior. If he fosters jealousy, actually, you know what? I'm going to come out and say, I think he does. If that led to Kaitlin committing this horrendous crime, that's not an excuse. It doesn't make it okay. It doesn't make it understandable. What he's saying here is not that it excuses it. He's saying, look, Colin fosters this insecurity. She felt the insecurity. Yeah, she was mad. Yeah, she called Mo. And I like that he says, oh, come on, let's be real. You know, it probably was about more than just the helmet, right?
To send Colin a snarky text message. And there was an Instagram story of Colin in a photograph with Mariah Wilson. Undisputed. Kaitlin texted, give my regards to Mo. That doesn't make a murder. It's possible that Kaitlin viewed Colin's text messages. Undoubtedly. Just as Colin testified from the witness stand that Colin had done the exact same thing in past relationships. You 14, and the 12 of you who will decide this case, are a relatively unique species in Travis County. You are a diverse jury. You are a diverse jury of age, gender, of experiences, and of race. That is uncommon in this county. I want you to bring that diversity of life experience into your deliberations. I want you to look out at this assembled audience. And I want you to wonder, as generations are different, this morning, someone advised me of a new app the kids are on, Flip. Hadn't heard of it until this morning. Young people communicate a little bit differently. But I would bet you every penny that I am worth that at least one of you has looked at your partner's text messages at some point.
That's brave.
Everything that I'm worth, and him, but that's true of a number of the people that are in this audience. The younger they are, the more common it is. Because jealousy is a fundamentally human emotion. Because it is about lack of trust in a relationship. But we know what Mr. Strickland shared with us about Kaitlin Armstrong. That in October of 2021, when Colin Strickland was having his short relationship with Mariah Wilson, that Kaitlin Armstrong was on dating apps. That Kaitlin Armstrong was dating other people. We know that Colin Strickland told you that at the cyclocross events in Bentonville, Arkansas, in January of 2022, that Kaitlin didn't appear to him jealous in any way. Nothing remarkable about her behavior to him. And in fact, we know that he shared that, yes, he'd had a long-standing sexual relationship with professional cyclist and woman, Amity Rockwell. And that Kaitlin was friends with Amity Rockwell. That Kaitlin had never expressed anything approaching jealousy or negative emotions about Amity Rockwell. Mariah Wilson was not the first cycling woman in Colin's life.
Mariah Wilson was different because of the way Colin spoke about her. She was this prodigy. She was amazing. She was a lot younger as well. And we know that Kaitlin's previous behavior, because I always look at previous behavior to tell me, what is this person like? What does this person care about? Her previous behavior was that she went for Botox. I'm talking before the plastic surgery, before any of this happened. So she's already concerned about that sort of thing. We also know that Colin says things to women. Like he said to one woman who is a professional cyclist, said, oh, well, you're not skinny enough. So she's insecure. And here is this young, beautiful, professional cyclist who's just sort of exploding onto the scene and is wowing everybody. And Colin speaks highly of her, best in the world. So this isn't just any woman. So that's my sort of devil's advocate argument on the other side, that Mo is different. Mo is more of a threat. The other thing I will say in favor of the defense is the best predictor of future behavior is past behavior. Now, that's not absolute, because in different circumstances, people will respond in ways that they've never responded before. So he is making a good point here.
Colin hid his relationship with Mariah Wilson into 2022. He did that because he didn't want to be honest about it. He doesn't like emotions. He likes what he wants and what's important to him. He was breadcrumbing. I think you know what that is. He was leaving his options open. He just didn't want to get caught. He didn't lie because Kaitlin was a jealous psycho killer. He lied because that's how he approaches life. That's how he approaches women. He's a professional cyclist and an amateur liar. Well, what did Colin Strickland say about Kaitlin then? He said the relationship was not volatile. Kaitlin was not a particularly jealous girlfriend. He shared he'd had girlfriends in the past before Kaitlin, and that Kaitlin was not jealous like those other past girlfriends. Who brought up jealousy first? Austin Police Department Detective Richard Spittler. On May 12th, mere 12 hours after the murder of Mariah Wilson, the Detective Spittler interviewed Colin Strickland, who first said that J word, Richard Spittler, because it was a great theory. And what a convenient narrative. What a wonderful and easy way to paint a woman and to tell a story. The woman scorned. Whether the facts met the narrative or not, it's a great story. The truth of the matter is that Kaitlin's emotions and her actions were normal and routine and human. But she had to be portrayed as a jealous psycho to create the motive. The problem, however, in Colin and Kaitlin's relationship was not Mariah Wilson. The problem was always Colin Strickland. However, Colin's behavior does not make sense. Colin changed Mariah Wilson's name in his phone on May 11th. Colin deleted his text exchange with Mariah Wilson.
What? On May 11th? I was under the impression that he kept her name as somebody else's name for a long time. Like it was just, that was how it was. But he did it on May 11th? Oh, that's interesting. Man, I wish we could have seen this whole trial. Wow.
On May 11th. What was different about May 11th? Why did he do that on May 11th? He felt he needed an alibi. Why that day? Jealousy. But what about the black Jeep? You know exactly where and exactly when that Jeep traveled. There is not a doubt that Kaitlin's cell phone was on her person between about 5:30 p.m. and at least 7:30 p.m. On May 11th. There's no dispute whatsoever as to that. And there is no doubt of any type that Kaitlin's cell phone was in the vicinity of the black Jeep. Kaitlin in the black Jeep. Who had access to the black Jeep? Who had access to the key fob to the black Jeep? Who had access to the key bowl containing that fob that drives the black Jeep? Who previously owned a black SUV? Pam Mazak presented you a compelling PowerPoint. Animation, details. PowerPoint presentations in criminal cases like this are a lot like swimsuits. What they reveal is interesting. What they hide is what's essential. It's real easy to look at the animation that Pam Mazak provided and see ... call detail record time ... and then to see infotainment track log ... And if you don't review the data, if you take it on the word of a PowerPoint animation, it's really easy to look at it and go, the phone was in the car, it was riding together. There is a very, very good reason that you were shown a PowerPoint and that you were not presented the data. When you return to the room back there to deliberate, ask for the PowerPoint, ask for the actual data. The problem isn't data in your heads. The problem is the presentation of it. Because what you'll see, if you actually look at the data, is that you were left with an impression that is not true. Look at the timestamp on the call detail records compared to the infotainment. You're going to see a lag. And sometimes you'll see an advancement. And what you'll see is that while it is undisputed that the phone was in the vicinity of the black Jeep, you'll see that there is zero conclusive evidence that phone actually was in the black Jeep. What you will see, though, is some really peculiar movement of the black Jeep. Peculiar movement that Pam Mazak completely skipped over. When that vehicle is heading northbound on Lamar and stops near an area called Spa 7, or maybe somebody had an appointment, or maybe not, you're going to see some very strange movement of the data within a parking garage. And you might wonder why that car may have gone up and down inside a parking garage, and why when the car is moving inside a parking garage, the phone is not in that parking garage. The phone is inside of a building. Other vehicles. What about Colin's mom's car? What about the Mercedes? What about the trucks? What about the half dozen odd vehicles? Did Kaitlin Armstrong have access to vehicles that weren't the black Jeep? Absolutely. Did she drive vehicles that weren't the black Jeep? Absolutely. But wait, Rick Topher. Colin said, I saw her get out of the black Jeep. What he said. The first time he testified in front of me, a few weeks ago, it was a Friday, he said that's what I believe. He was real hesitant. He wasn't rock solid. Then he had a weekend to think. And he came back and he continued to testify.
So when he's saying, yeah, Kaitlin had access to other vehicles and other people had access to her vehicle, I mean, who else besides Kaitlin and Colin would want to use that vehicle, who would want to go to Cash's residence on that night in the black Jeep. The only two are Colin and Kaitlin.
By in front of you on Monday. And somehow his memory and recollection of every detail in this case had become fuzzier between Friday and Monday over the weekend, except for his opinion about seeing Kaitlin come out of a black Jeep. And when he sat on the witness stand and testified yesterday, somehow all of his recollections had become even fuzzier still, except that he claimed he saw Kaitlin Armstrong come out of a black Jeep. How amazing that the one fact that he seemed to remember with greater clarity over time was the single fact that drew attention away from him and pointed the finger at Kaitlin Armstrong. We're to believe this, that that's what he said, that that's what he actually saw. From Colin. Colin!
All along, he has been hiding and doing whatever he could to make sure that people see him in a good light, to make sure that no fingers get pointed at him. Okay? He hasn't always pointed the finger at Kaitlin. So it's not like he framed her or anything like that. I don't think his main goal is to make sure that this is pinned on her so much as it is to make sure that he is not the one seriously looked at for the crime.
With his marked lack of interest in Kaitlin's life, Colin, who on May 12th said that Kaitlin had arrived home mere moments after he texted her at 9:21 p.m., 6 minutes after the killing of Mariah Wilson. Colin, who couldn't recall a single detail about Kaitlin's behavior that day, that does not make sense. And Colin may have had other reasons for saying what he did. Remember, Richard Spittler did not believe that Colin was truthful and forthcoming. What about those guns? Colin bought those guns. Colin told her to train with the gun. And she did. Once. And she was totally normal. I asked the witness, Jill, did Kaitlin seem all murdery? No. Now, the prosecution led with a video of her at the gun range. Raise your hand in the audience if you've ever been to a gun range or ever held a firearm. Did you kill anyone? It's emotional, compelling, but that's a rabbit hole. That's a smokescreen. But what's peculiar is that Colin sat up here on the witness stand and said, oh yeah, no, that cable lock for the gun, yeah, that was mine. I have no idea where the second cable lock came from. He had no problem admitting that he owned a cable lock before buying guns. He had no problem admitting that he owned a red cable lock on a Smith & Wesson, which appears unaffiliated with this case. But when confronted with the evidence, I have no idea where this black cable lock on the black Sig Sauer came from. And when...
Oh, that's interesting. And not necessarily in terms of this particular crime. I think there's a whole lot to Colin Strickland under the surface that people aren't, I don't know if they're not seeing it, but it's not out there. Let's put it that way. Not only had he purchased the Sig Sauer and different Sig Sauer earlier, and his statements were inconsistent about whether or not he'd fired it, whether or not he knew how to use it. He already had a Pelican case for the firearms. He also said at the end of his statement to police, and I don't have that one out yet. I am going to finish the series regardless of what happens here. He also asked the police, well, can I go get another firearm? Is it okay? Because I think I want to buy another gun. And he also said in his statement that Kaitlin knows I'm interested in these things and that I want her to learn how to use them. So that was very interesting, that little tidbit.
We invited him to come and demonstrate to you, to stand here, to show you how a cable lock works. Suddenly, Colin Strickland, engineering degree, Colin Strickland repairs and sells Spartan motorhome trailers. Colin Strickland, the mechanically sophisticated man, suddenly he has 10 thumbs, and I don't know how this works. Bullshit. He wasn't straight with you.
Good for
him. He knew
him.
exactly what that cable lock was. He knows exactly how it works. And the reason that he was blowing smoke to you is because he did not want you to see that the usage of a cable lock is no easy feat. To rack the slide, to eject the magazine, to then replace it. And so Colin wanted to leave you with the impression, I don't know. The black, I have no idea. The thing from the murder, I don't know. And yet somehow Kaitlin Armstrong, who appears at best, had in her life held a gun one time, somehow knew to use, to remove and then reattach a cable lock. When you heard from Jill from the witness stand, Kaitlin didn't have any experience with that. When they went to the gun range at Colin's direction, there was no cable lock. How did the cable lock get on the gun? Colin says he didn't do it. We know Kaitlin didn't do it because Jill said so. That does not make sense. But Rick, what about the DNA? Rick, Kaitlin cannot be excluded as a potential contributor to a DNA swab from Mariah Wilson's bike. Period. Full stop. A swab from the handlebars and from the seat of that bike.
Mm-hmm.
I am no DNA expert. None of y'all are either. We heard from several of them. I don't know. I know that there's transfer DNA. I know that there can be lab contamination. I know that there was a lot of conversation about helmets and who wore what helmet and when they wore it. And you know who wore the helmet when and this and that. Or did Colin put on a black motorcycle jacket as he discussed with Richard Spittler on the way from Kaitlin Cash's apartment to Deep Eddy and Poolberger? Would that black jacket have his DNA? And then if Mariah with Kaitlin and the... I don't know. You will make of that what you will. But the upshot is this.
I'm surprised that he's saying, I don't know, and not pointing to some expert testimony. When I heard that the DNA was found on the bike, I went to a friend of mine, because I'm not a forensics expert, but I know somebody who is, and I asked the question, how would this happen if she wasn't there? How is this? And it could come from Colin, but that would mean Colin would have had to have handled the bike. So I'm surprised that he's just saying, I don't know, you're going to have to think about it. I wonder why they didn't really go after that one, because that would have been, I think, a stronger argument.
There are two realities. Schrodinger's cat. Either Kaitlin Armstrong was there, and that's why there's DNA that was found on that bike, or at least that she cannot be excluded, blah, blah, blah.
It was hers.
A person wearing gloves had their hands on a driving steering wheel that had Kaitlin's DNA.
Oh, yeah.
Or Mariah Wilson had touched the same bike, or the same helmet, or the black jacket. I don't know.
Yeah.
I do know one thing. Every person that handled this bike handled it in the same way. It was arm day at the gym this morning, and this is still really easy because this is how you pick up this bike. But what the government and the police would like you to believe is that after a brutal slaying, that the way, and see how this tire is arranged, that the way then, Kaitlin Armstrong would have, I guess, wanted to hold the bike like this. That does not make sense. Everyone held it this way. And what's astounding, and this is what you heard from the APD expert, right here, on this portion of the bike frame, this was the area not swabbed for DNA.
Mm-hmm.
Why not? It was more appropriate for latent prints. Could you have swabbed for DNA? Absolutely. Why didn't you? It was more appropriate for latent prints. No DNA here, but why would anyone?
If he's going to make that argument in respect to Kaitlin, that argument then would hold true in respect to Colin. Because Colin wouldn't handle the bike that way either, right? He would pick it up from that center bar, just like everybody else did.
That doesn't make sense. But what about the missing DNA analysis? No analysis of any DNA from that bike frame. What about the swabs taken from the black Jeep? You heard testimony. DNA swabs were taken from inside the black Jeep. Never tested. Why?
Why?
Why not? Why leave it to chance? What if it had shown yet another unknown profile? How inconvenient. We do know as a fact.
I think that's a rabbit hole.
Unknown DNA profile on the seat, unknown DNA profile on these handlebars, unknown DNA profile on the gun. That does not make sense. Austin American Statesman got it right. There's mystery DNA. And there's one more source of DNA that was never tested. The rape kit. The truth of the matter is, Austin...
Why on earth would you not send that one for testing? Even if there wasn't a full-blown assay, it would be useful. If there was an attempt, if there was a struggle, and we know Mo had defensive wounds on her, there would be DNA on her. Also, Colin Strickland, near the end of his police statement, launched into an explanation, a weird explanation, of why the police might find his DNA on Mo, in Mo's mouth even. And so it's astounding that this kit was not tested. I do question, though, why did the defense not demand that it be tested or demand that their experts get to look at it? So he's arguing this here. Anyway, that is just an astounding little bit of information.
The police department did not want a single piece of evidence in front of you that might point away from Kaitlin Armstrong. They didn't want any evidence that could potentially be inconsistent with their version of the case. And that's why the black swabs from the Jeep, the DNA swabs from the black Jeep were never tested, and that's why the rape kit was never tested. Rick, what about the police interrogation? We saw her on the video for 11 minutes. She looked cold, she looked bad, she looked like a killer. Imagine that your boyfriend has just been contacted by 2 homicide detectives and told to come down to homicide. And that not but 60, 90 minutes later, additional law enforcement arrives, tactical vests, guns. You're under arrest. What am I under arrest for? Don't know, can't tell you. And then you're taken down to be interrogated, put in a room with Katie Connor, who may not be the worst homicide detective I've ever seen, but is certainly in the running. And told, oh yeah, you're under arrest on this warrant. I couldn't tell you a thing about it. I don't really know. Oh, is someone knocking? No, no one's knocking. Oh no, I think they're knocking. Kidding. our bad, you're good to go. Hey, your boyfriend and the... What would you do? How would you respond? Don't you think you'd be a little confused? Rick, come on, Costa Rica. What are you, an idiot? Come on. She ran. She ran. Only a guilty person would run. Are you a fool, Rick Kofer? And yet you heard testimony that Kaitlin was told by the Austin Police Department, free to go, ma'am.
Mm-hmm.
And when she went to New York, free as a bird, just like any of the 14 of you. And when she booked that ticket for Costa Rica, when she drove to Newark Airport, when she got on a plane bound for San Jose, what did Richard Spittler tell you? That the murder warrant that he had gotten about 10:30 p.m. on May 17th, 2022, had not been entered into TCIC and CIC. At the moment she bought that ticket, at the moment she was on the way to the airport, got there when that plane was taken off, there was no way in the world that Kaitlin Armstrong could have had any awareness or knowledge in any way whatsoever that there was a warrant for her arrest. But we do know that Kaitlin Armstrong routinely...
You could argue, though, what he's saying is true, that's true, but you could argue consciousness of guilt and say it doesn't matter that she knew or didn't know that there was a warrant. She knew she was guilty, so she ran. You could also argue other reasons. She was scared. She didn't trust her boyfriend. I mean, did he do this or didn't he? There are other arguments for that. And the other thing is, when the police were searching the house, Colin left and went to his dad's. He didn't want to be there and see that. He didn't want to be around for that. Kaitlin stayed there. She stayed while they did the search outside. If she was conscious of her guilt and fearful, that would have been the time to run. You could argue that in several ways. It's not necessarily one or the other.
Routinely traveled internationally. We know that she routinely traveled internationally with little notice. There were multiple witnesses who testified to that, and we know that she did it related to her yoga. Was she scared? What do you think? Do you think that she may have been concerned a little bit that her boyfriend had killed someone? Or if not that whoever killed Mariah Wilson might want to kill Kaitlin Armstrong next? Or that this might have been connected to the vandalism, the unexplained vandalism outside her house? Fear. Fear results in fight or flight.
Yeah.
And it was flight. And she certainly was afraid, and that's a reasonable conclusion you can draw. Rick, a couple of weeks ago, she ran away. They took her to a medical appointment and she ran away. Guilty. Why are we even here?
Different. It's different.
Terrified woman. Fearful woman. In jail. Abused. Injured. Someone who doesn't know what they're doing.
There's been no testimony about the things you talking about now.
I'm moving
He
on.
can twist the evidence any way he wants to, but he can't try to add new evidence.
That's the case against Kaitlin, right? Isn't that what it boils down to? Did I miss any of the big points? Isn't that where we're at, that circumstantial evidence case? It's a simple case. It's an easy story. It's a beautifully simple story. But it's wrong. And it's based on assumptions of gender and of motive and a bias toward confirmation. And who got to investigate this? Richard Spittler on his first homicide. Why test a rape kit? Why would I need Colin's laptop? I looked through it. I mean, sure, I've got no background in digital forensics, but I looked through it. It seemed fine to me. Let's return it to Colin.
Wait a minute. They didn't do the forensic exam? During Colin's interview, he was pushing, saying, look, when can I have my computer back? And I left it, when I put it in the video, I left it in there for the sake of completeness. But I thought, this is boring because it's such a standard question. Anyone who has their phone or computer taken by the police says, gosh, when can I have it back? I really need it. I mean, everybody's like that. So it was a normal question. And Dick had said that the computer was currently plugged up. I think he meant plugged in. I don't know if that's a slang or a way of speaking. Anyway, he said the forensics guys, the DFU, Digital Forensics Unit, was going to look at it. And Colin was saying, well, I kind of need it back. So after the interview ended, did they just kind of look through it and then give it back to him? Holy crap. I mean, that doesn't mean that there was anything on it that would be of concern or even relevant, but geez. Regardless of the outcome here, if you look at this whole thing, the way he was treated is very different from how she was treated right from the beginning. He got a lot of graces extended to him that other people wouldn't get.
One single solitary piece of physical evidence has been removed from this case. Colin Strickland's laptop. Why was Richard Spittler so eager to get Colin's laptop back to him? Why does Colin get treated differently than everyone else? What about Colin's iPad? Why was it never seized?
What?
Why was it never extracted?
What?
Why didn't Richard Spittler bother to contact or investigate any potential suspect until months and months after he had issued an arrest warrant for Kaitlin Armstrong?
Television.
He calls Alan Lamb, a putative lover of Mariah Wilson. He calls Gunnar Shaw. Surely he did that in the days after the murder. No, he did it in July. And he did it, as he said, because he doesn't know what the defense is going to pull. Guess what? Alan Lamb didn't kill Mariah Wilson. Gunnar Shaw didn't kill Mariah Wilson. Did Richard Spittler know that on May 17th? Nope. He didn't even know their names. That was the level of his investigation. The vandalism, the video that you saw yesterday, where Richard Spittler is energetically taking notes, what happened to those notes? Where Colin Strickland is showing the photographs of that vandalism, what happened to those photographs? Richard Spittler thought so little of it.
Oh boy. Okay, so the fact that Spittler didn't do things properly does not mean that Kaitlin Armstrong is not guilty. However, it does tell you something about the quality of the investigation and the reliability of how things were put together, especially if Spittler had a bias. And I really think that he did have a bias. And I could back that up. I could argue that all day long. He was biased. Does that make her guilty or innocent is a different question. This is a little bit sort of going a little bit of redirection, but this bit about, okay, Colin's iPad was never seized. What the heck? And the notes, the officer's notes, that's really important. Whenever you are doing a case, whether you're on the side of the prosecution or the defense, you want those officers' notes, all of them, from everything, every little thing that they did on that case. You want those notes. You want the notebook. And some lawyers, because it's happened where officers have gone back and sort of added in notes. There was a case here where a lawyer sent the officer's notebook for forensic testing to test the age of the ink, and learned that the officer had used a different pen at a different time to add a detail into his notes that was going to be important at trial, and it became a big deal. And officers' notes very often contain little observations, things that they thought, they noticed, that does not end up in the final report. Those officers' notes, and I can tell you, I worked on a case that completely unraveled because within the officer's notes, there were details that led to questions that ultimately led to further investigation, further evidence being uncovered, and led to the exoneration of a man who did not do what he was accused of doing. So those officers' notes, they are important. It sounds like a stupid detail, but they really are important. They know this. So why does somebody who is a homicide detective lose his notes? What is with that? And again, that doesn't make her innocent. It doesn't make her guilty. We don't think. Because if there was a detail in there that led to other questions, if there was a third person, say somebody really jealous of Colin and did that to his house, that vandalism with the dollar bills under the rocks, the police need to look at that person. The police need to talk to that person. Could that person have been stalking Colin and have seen something? It's just ideas that you could come up with or throw out anything. The point is, that means there's a whole lot that they can't know, that they'll never know, that they can't ask about, that they can't dig into. No matter what you think, whether you think that Kaitlin is guilty or not, two things I think hold true. And one is they have to make sure that they get the right person. Convicting the wrong person is not justice for the victim. It just heaps on another injustice. So that's one thing. They have to make sure. The second thing is that the process of how investigations go, of how much you need to have, how it is that somebody gets accused, what is available to a defendant to fight back, to protect themselves, those standards are upheld. That is stringent, that there's a high bar. Because if the police can just be willy-nilly, then anybody is at risk of being accused wrongfully. And even the public doesn't get answers as to, is this right? This is the information we're presented with, but are we missing anything? So that whole notebook thing, that's really bad. Like, I know it sounds like a stupid thing, but it's actually a big deal. I mean, I don't know, if you're on the jury and you've never sat in court, you might not think this means much, but it does. I'm rambling. I'll keep going, sorry.
That he violated Texas law, that he refused to provide this district attorney's office that report, he refused to conduct a single scintilla of investigation. Why? That didn't really fit the narrative, did it? So why look into it? Why would it matter? He didn't test the DNA from the black sheep, but he did go and get an arrest warrant based on hearsay and innuendo and anonymous phone calls. He didn't even bother to watch the 11-minute interview of Kaitlin and Katie Connor. He claimed that there was a NIBIN investigative lead when there was none. But we know one thing, he testified he knew Colin from before. What a world to be treated like Colin Strickland has. So what happened here? Police think Kaitlin committed this crime. They don't know. She fits their story. She fits the story they created. A spurned, jealous lover. That story is so easy. That story is so easy to tell because it ties into a framework of patriarchy and misogyny that is rooted in American culture. Humans want to know answers. We don't want a mystery. That's part of why wrongful convictions occur. Michael Morton, Greg Kelly, what exonerated them? DNA. So if Kaitlin Armstrong did not kill Mariah Wilson, who did? I don't know. A much better lawyer than me, Bill Fitzgerald, was asked that same question in the Michael Morton trial. If Michael didn't kill Christine Morton, who did? His answer, I don't know. And the reason that answer is so unsatisfying to you is because we as humans demand closure. We demand explanation. A mystery ruins it. And someone had to sit in 30 years in prison before the real killer of Christine Morton was found. And then that chapter was closed. But we do know a few things. We know what Colin Strickland actually said. That he considered Kaitlin to be an incredibly kind, caring, and sweet person. That Kaitlin had only shown absolute above and beyond examples of human compassion and thoughtfulness and care and going far out of her way to help others. Colin said Kaitlin is a mild and gentle person. Colin said Kaitlin is not a particularly needy person. Colin said he could not imagine Kaitlin hurting anyone. Kaitlin had never done anything violent in her life, according to Colin Strickland. Kaitlin had never been violent, says Colin. How did Colin sum her up? Kaitlin was soft. So what happened? Anyone could have entered that unlocked apartment. Why was it unlocked? Mariah Wilson locked the door to Kaitlin Cash's apartment when she left to go out with Colin. She knew how to lock it. She did not lock the door when she returned. Was she expecting Colin to come back? Was she expecting someone else? We will never know. Detective Spittler, Detective Connor, the Austin Police Department flubbed this.
The evidence showed that she was on her phone up until just before the crime. So I think he's reaching a little bit with, well, anybody could have. Technically, yeah, he's correct, but who would have, right? So maybe somebody who had seen her there, seen him drop her off and knew she was alone. But then that doesn't explain that it was Colin and Kaitlin's weapon used in the crime. So what? This anybody went to Colin's house and got Colin's gun and committed the crime and went back to Colin's house and cleaned the gun really well and put it away? That doesn't hang together. But Colin or Kaitlin could have gone in there. Colin could have gone back and she would have let him in. Kaitlin could have just walked in, but how'd she know the door would be unlocked? How would she know where to park and that she could take the bike? Like, those questions still aren't answered. So he's going off like anybody? No. Is Colin or Kaitlin?
Case. But I guarantee you one thing. If you convict Kaitlin Armstrong and she's eventually exonerated, you'll know right now the basis of it. Untested DNA.
That is inappropriate argument. That is inappropriate argument to the jury. And somehow imply that they might make a mistake and come back. That is improper. Put that kind of pressure.
The judge is nodding.
I have no further argument.
Yeah, that was something.
Mr. Purrier will join you now.
Wish she didn't do that.
I don't know. I don't know. A guilty verdict, proof beyond a reasonable doubt, means putting the I don't knows that you have in a box, moving them aside, and pretending they don't exist. The I don't knows that you have are something you need to start thinking about. This is the time to do it. Those I don't knows are important. I don't know why Cash's apartment was unlocked. I don't know that. I don't know why Mo was clutching a black baseball cap 45 minutes after she got home. I don't know that. I don't know why Colin lied. And I don't know why he lied about lying. I don't know that. I don't know why Detective Richard Spittler didn't test the sexual assault kit. I don't know that. And I don't know why he didn't test the swabs from the black Jeep. I don't know that. And you don't either. And that is the whole point.
And you would expect, after a shooting in that small of a space, right, that there would be some microscopic evidence, that there would be some small amount of blood, gunshot residue. The Jeep should have been tested, and that is shocking as well. Why it wouldn't be swabbed. I don't get that. Why would you not?
Of this trial is that those I don't knows are important. And it's easy to disregard those I don't knows. Mm-hmm. It is easy to swipe those off the table, right? And just accept Detective Spittler's version of what happened. Just to accept that narrative, right? That's the easy thing to do. But while jury service, the service that you're doing right now, is a privilege, it's also a duty. It's not supposed to be easy. It's not easy. It's difficult. But that's why you're here. That's why you're here, and you're here, and you're here, and you're here. Because way back, weeks ago, when we were talking in jury selection, we observed you to be thinkers. We observed you to be gripped with the courage to ask the tough questions. We observed you to be willing to set aside your basic assumptions.
He's so obviously blowing smoke up their butts. He could at least veil it a little bit better.
About what it means to be accused of a criminal offense. That's why you're here. And it's not easy. It is difficult to ask those tough questions. That is difficult. To address those I don't knows. That is difficult. But that is why you're here. Let's talk about DNA. You heard from at least 3 experts about DNA, and you heard a lot of different perspectives about what DNA is, what it means. But one thing that they all agreed on is this. DNA means that a clump of cells was found in the exact spot that they were collected from. That is what DNA means. And we have a tendency to mythologize DNA, right? From what we see on TV, from what we see in the movies. We have a tendency to mythologize it, to put it on a pedestal as meaning something that it doesn't. DNA is an artifact, just plain and simple. Now, I think what you've seen, despite what Dr. Calfett told you yesterday in court, is that it doesn't confer a crystal ball on anyone. It doesn't confer on anyone a time machine, the ability to go back in time, like a Christmas story, to revisit things that happen from an observer standpoint and be able to create a narrative from it. It is not scientifically defensible. It's just not. The state's own expert, Samantha Perkins, testified that you can't fabricate the kind of narrative, the kind of probabilities that Dr. Calfett wanted you to believe he can create in his mind simply from the presence of DNA. All DNA is an artifact. That's it. That is the scientifically defensible.
These guys, it's like so much spin on both sides, right? So yeah, it's an artifact. And yes, it does mean something. Is it true that there's transferred DNA, that your DNA could end up somewhere where you weren't physically? Yes, that's true. But it does say something. So the DNA there means that either Kaitlin or Colin touched that bike at some point, probably more recently because DNA does degrade. Then the question is, when did they touch the bike? Where did they touch the bike? And what reason might they have to touch the bike? Colin did not end up going on a bike ride with Mo on that day. He would have no reason to touch it. And Kaitlin would have no reason to touch it. And the unknown person's DNA, we don't know who that was. And we don't know if that person had a reason to touch it or not. So this is such a stretch. Oh, it's just an artifact. It doesn't mean much. Well, actually, yes, it does.
Sensible position to take. Now, Dr. Calfett wanted to take it a step farther, right? To write the script for you that is not scientifically defensible. And their expert acknowledged that. It's just not. Ballistics, let's talk about that. Now, I think, despite the length of the testimony, Steve Aston and Bill Tobin, I think, agree on a lot of things. There's a lot of overlap in the position that they take. Now, Bill didn't get up here and tell you that it's junk science, that it's ridiculous, that it's preposterous, and bring a bunch of conspiracy theories to you. No, he didn't take that position at all. In fact, he worked at the FBI. He worked side by side with those examiners for more than 20 years. He wasn't here to tell you that it's just junk science, that it's completely unbelievable. Quite the opposite. That's what you heard. And I'm going to disagree with the state's characterization of his answer on that last question. He didn't say, I absolutely agree with Steve Aston. I absolutely agree with his opinion. Sure. 4 hours wasted. If that was his opinion, it would have lasted 5 minutes. That wasn't his opinion, and you're smart enough to recognize that. His opinion was, Steve Aston is entitled to his opinion. He's entitled to tell you what he thinks it is. He doesn't agree with it. But it's a subjective science. It differs from person to person. Of course he's entitled to his opinion. Every firearms examiner has their own opinion. It is subjective. That's the whole point. That was the whole point of his testimony.
He said a key word that I wish they would really capitalize on, and the word is characterization. This particular prosecutor is very good at what he does, and a lot of it is characterization. The other thing I'm noticing is that they are actually arguing facts and not necessarily arguing the law, unless we just haven't got there yet. There's kind of a joke among lawyers, at least lawyers I know. It's like, well, if the facts aren't on your side, then argue the law. They're still arguing facts. So they're not saying, yeah, the facts are true and we're just going to argue about the law. We're going to make sure it's not admissible or something. No, they're arguing facts. So
doubt Mr. Aston's ability to make very experienced observations about tiny lines that may be present on shell casings, on bullets, on projectiles. But just like their DNA expert, Dr. Calvin, Steve Aston wants to take it a step farther, to go beyond the science, right? To be able to say, this gun fired this bullet, this gun ejected this shell casing. To make it say things that it doesn't say. Mr. Tobin recognized the limitations of what ballistic science, what firearms and tool marks examination can say. And what is that? That based on Mr. Aston's examination, it is consistent with being ejected from that gun. That it was possibly the source of the fired cartridge casings. Possibly. And guess what? That is exactly the language that you'll see in the DNA report. That it can't be excluded. That it is possibly the source of those shell casings. That it's possibly the source of those projectiles. Now, Mr. Aston wants to take it a step farther and say, this is it! We got it! That is not scientifically defensible.
he's reaching.
Now, I know what you're going to say. Mr. Puryear, you guys paid Mr. Tobin to come in here and say all those things. He's a hired gun, right? Fine. Don't take his word for it. Disregard everything he said. Disregard his opinions. Take that off the table. But I'll be real with you folks, I don't have the juice or the disposable income to convince two separate groups of the most preeminent scientists the United States has to offer who agreed with his position. I don't have it. I wished I did. I don't have the pull or the ability to go back in time to 2015 and talk to President Barack Obama and convince him of his legitimate concerns for the limitations, the reasonable limitations we can put on that field of forensic science. Who had concerns about setting boundaries for the kind of unqualified, reckless opinions that Mr. Aston offered you in court. I don't have that ability.
That's pretty extreme. Those are harsh words. This isn't, we disagree, the science is in question. In recent years, this information has cast doubt on this field or in certain aspects of this field. He's saying harsh personal words about a specific person. Reckless? Unqualified? I don't know, man. He's not likable. I know that the guilt or innocence of a defendant should not depend on the likability of the lawyer, but I'm telling you, yeah, it makes a difference in respect to how they consider the arguments, at least, right? If you're listening to somebody that you think is full of crap or that you don't like them, you might not take him as seriously as the guy you're really connected with. And the guy who seemed to make sense and he was smooth and he reached into the emotional part of you. And I've yet to hear from the defense much compassion for the victim. Now, I know that's not about guilt or innocence. I know that. But no matter who did this, no matter what happens at the end of this trial, Mo Wilson was innocent. And this crime was horrendous. I don't like his harsh words. I'm going off on a tangent. Let's get back to it.
Now, I can tell you that our president back in 2015 had those concerns. I can tell you that those groups of scientists had the opinion that individualization, that ability that Mr. Aston claims to have, is not supportable by relevant science. That was the opinion of the brightest minds, brightest scientific minds this nation has to offer us. That was their opinion. Don't take Bill Tobin's word for it, but you can trust that group. Now, he has a job. Steve Aston has a job because he claims he has that ability to come in here to court and say, this gun fired these bullets, right? That's why he has a job. There's not a detective or a DA's office in Texas that has any value for an examiner that's going to come in and say, this gun is consistent with a production lot of 2,000 other guns that could be the source of those bullets and casings. Not a one, right? His testimony is consistent with keeping his job. Testimony like that isn't what the police want to hear.
That's unfair. And I think that this line of argument that there is somehow malice or self-serving, I don't think it's going to go over well. What do you think? It's one thing to say, you know what, the detective had a bias, because that happens. That doesn't mean malice. Somebody doing a job could be worried about something or in a hurry to close it up or any number of other reasons why they might make a mistake. The way he's characterizing this professional, this man, is harsh, and I think it's uncalled for. It's not necessary. I don't think it's helpful. I could be wrong. I'm not a defense lawyer in this case, so...
Let's talk about Kaitlin's interview. Why she reacted the way she did. Why she requested an attorney. How much trust would Kaitlin have in the competence or professionalism of the Austin Police Department after that experience on May 12th? She's arrested on a silly minor charge in front of her house, in her neighborhood, dragged into the station. Then she's escorted into a room. She's told, we need to read you your rights. It's a very important situation. She's never read her rights. And then they come in and say, oops, sorry. No warrant, just kidding. But hey, stick around for a few minutes. And then they come back later on and say, oops, we goofed again. Turns out you do have a warrant. How much trust would you have in their competence? Put yourself in her situation. If that's me in that room, I'm looking around for game show cameras. Is this a joke? This can't be real. That is what you heard. But what else did Katie Connor tell you? That Kaitlin on that day, the day that she left for New York City, the day that she left for Costa Rica, she was as free as you or I or Detective Katie Connor to fly across the country, to fly out of the country, right? That's what you heard. So it's easy to say she fled. It's easy to say that. That is not what the evidence supports.
Until later.
Able to go anywhere she wanted to. And from a deeply ingrained primal place in our brains, when faced with fear, when faced in a stressful situation, like my colleague said, what do? It's fight or flight. That attempt to retreat, to find a safe place, to find a place of comfort. And she's not alone in that. Colin did the same thing.
Mm-hmm.
Colin went to his dad's house. That's a place that I felt safe. That's a place that I felt comfortable. That's a place that I felt good.
He went further than that. He actually left Austin and he was in hiding. While it's true, yeah, she was free to go. Yes, it actually is completely understandable why she would fly to Costa Rica. It really is. The part that he's not addressing, and I don't know if he will, is that when she looks up the incident or the issue on her phone to find news about it, she does find out that there's an arrest warrant and she goes and has plastic surgery. At that point, she is fleeing, even though she's not physically moving from one place to another.
That's a natural reaction. And it's easy to say, well, I would have done something different. It's easy to project what you would have done on somebody else. We all react differently to stressful situations. Now, I want to talk to you about some other things that we talked about. Do we believe that David Harris killed Mo Wilson? No, we don't. Of course not. The point is, there was no investigation into him at all because Detective Spittler had tunnel vision and he jumped to conclusions. Now, the government wanted to imply that this is a red herring, a rabbit's trail, a smoke screen, to ask any questions of Detective Spittler about the failures of his investigation. That you should just disregard all of those things. Yes, Your Honor. Yes, Your Honor. What would be the evidentiary value of a forensic analysis of that rape kit, the sexual assault kit that was collected? I don't know. We will never know because Detective Richard Spittler, didn't care. He didn't care enough to get it analyzed because he determined it wasn't important for you because he had tunnel vision and he jumped to conclusions. What would have been the evidentiary value of an investigation of the criminal mischief that happened at Kaitlin and Colin's house? I don't know. We'll never know because Richard Spittler didn't care.
There is value in testing the kit, even if nothing is found. Nothing being found would have eliminated or excluded a number of possibilities, or at least could have. Yeah, it's important. As far as the rest of it, yeah, they don't know what else was there. And how do you then defend yourself, right? You're given only the evidence that looks bad for you and nothing that is potentially exculpatory. And that's an important principle.
And because he determined that it wasn't important for you, because he had tunnel vision and he jumped to conclusions.
He did.
Now, we've all done hard work over the last 3 weeks. The state has too. Your job has been the hardest. And never was your job more difficult than maintaining your attention through the testimony of Detective Portman. My gosh. But what did he tell you? What did he tell you? That it was extremely irresponsible of Detective Spittler to return that laptop to Colin after just a cursory glance through it.
Unbelievable.
That was extremely irresponsible. And he did so with really no direct evidence or really any evidence at all to exclude Colin as a suspect. He just did it.
Not only that, there were loads of cues that would tell an investigator to dig more deeply into several aspects of his statement. There was a ton.
How easy would it have been to prioritize a download of that laptop, to have Detective Portnoy do it? He didn't do it because he had tunnel vision on Kaitlin Armstrong and he jumped to conclusions. Mm-hmm. Folks, trials like this are inherently difficult. A young girl's life was taken. That we have no doubt. And that is tragic. We can all agree on that. And you've heard things and seen things throughout this trial that understandably create strong emotions, that pull on your feelings.
Mm-hmm.
And the easy path is to let those emotions sway your decision, to let those dictate your decisions, to let emotion stand in the place of reason and common sense. That is the easy path to take. But the oath you've taken as jurors necessitates that you have the fortitude and the conviction to use your minds, not your hearts, as you analyze the evidence that was presented to you, and more importantly, the evidence that wasn't.
I think I might slightly disagree in a sense. I understand and I see it that people are rightfully outraged at what was done to Anna Mariah Wilson. It was horrendous, it is unjust, and nothing is ever going to fix that. If you're using your heart as well as your mind, then you want the person who did the crime to be held to account. The question is not, don't be emotional. It's where to put that in everything. That anger, that outrage is rightful. It should rightfully be directed at the person who committed the crime. Where people get mixed up is they feel the outrage and they're told, here's your target. And so that's where they direct the outrage. So the outrage is righteous. The question is, what do you do with it? When we're talking about such a horrendous crime, if somebody says to you, oh, don't use your emotion, don't let your emotion come into it, I think that's tough. Direct the emotion appropriately, put it in the appropriate place and context, and when you're considering the evidence, consider it with a clear head.
We say, I don't know. We're tempted to mean that we're unintelligent, right? Or uneducated. When we say those words, I don't know, it may even mean for a moment that we're confessing that life sometimes just doesn't make any sense, right? But that is what a not guilty verdict means. It means, in plain terms, we don't know. Not for sure. Not for sure. Not guilty doesn't mean innocent. It can mean something different, right? And we've talked about that. If you say not guilty, you're saying as a group, as an individual, we don't know for sure. And in most real-world situations, saying I don't know, that's not an acceptable answer, is it? To your boss, to a client. That's not acceptable. It is in the jury room. It is. And don't feel like you failed if that is your conclusion. Because again, the oath that you've taken as jurors compels you to say that if it's appropriate. Don't feel that you failed. In fact, it is your obligation to say those words if you believe they're true. You must only convict if there is proof beyond a reasonable doubt. And if you have doubt, and quite frankly, in this case, you must, then it is your obligation to come through that door and stand before us all and say in substance, we don't know. Not for sure. Thank you, Your Honor. Folks, in this life, we know a lot of things beyond a reasonable doubt, right? That Austinites love salsa, that we love our families, that it's raining when those rare drops fall from the sky, right? That the sun rises in the east, sets in the west. We know all of those things beyond a reasonable doubt. We know them to be true. But that Kaitlin Armstrong is a murderer, that she committed this crime? Do we know that? Are you certain? Do we know that for sure? Find her not guilty.
I think she's toast.
But Rick, why is the defendant's Jeep in the alleyway? But Rick, why is the defendant driving around Maple Avenue for over an hour? But Rick, why does her Jeep start up more or less 2 minutes after Mariah Wilson is killed? But Rick, why does the defendant have a 9mm pistol that even the defense expert says is possibly the murder weapon, and who the state's expert says is the murder weapon? But Rick, why does the defendant sell her Jeep, which we all know is evidence in a murder investigation, the day after?
Why was she driving around? Because she was looking for or following her cheating boyfriend. And this was many hours previous. The parked in the alleys, with the Jeep starting up right after the crime. I don't know how you explain that.
After she's told it's on video. But Rick, why does the defendant fly out of the United States using a fake name and a stolen passport to a different country where she uses fake names and goes and gets plastic surgery? Colin Strickland on video at Pullburger when the Jeep is driving around downtown. But Rick, Mariah Wilson was fully clothed when she was murdered. So when was she sexually assaulted? But Rick, Mariah Wilson was on her phone.
That's not right. An essay could have been an attempt. It doesn't mean it was completed. It could have been an attempt, and that's why the perpetrator brought the gun along in case he was not successful. There were defensive wounds on her. She made contact with the perpetrator. They physically engaged. That should have been tested.
The entire time she was at the apartment, so when was she sexually assaulted? But Rick, Colin Strickland was only at the apartment to pick up Mariah Wilson for about 7 minutes.
Pick up.
Rick, when did he have time to sexually assault her? And Rick, didn't they go out and have a nice dinner on video after the fact? So when did he sexually assault her? But Rick.
No. There is no allegation of an assault prior to them going out. And he is talking about picking her up, not dropping her off, not then, and not returning afterwards either, which was never ruled out as a possibility. So there's some fancy footwork going on here with time frames. And when does he have time? Well, you know what? To make an attempt, to make an attack, it takes seconds. It takes seconds to find out, to make the attack and find out that that victim is not going to be compliant and there's a struggle. You produce your gun, or you have produced your gun, and now you're in a position you have to use it, or you lose it and you use it and then go, holy crap. When does he have time? All this is playing with timelines in combination with spouting some myths here. I don't like that.
Isn't Colin Strickland on video at Pullburger when the Jeep is driving around downtown? So how can he be driving it? But Rick, Colin Strickland's phone tells us that he's in South Austin at the time the murder happened. So how could he have killed Mariah? But Rick, why weren't you listening when Dr. Colifut, the state's DNA experts, explained that he had never heard of a 4-time transfer level that would be required for us to believe the defense DNA theory? But Rick, isn't it likely that every single passenger who rode in the black Jeep would likely leave DNA in the Jeep? And Rick, how would that be helpful? But Rick, I know the defense doesn't have any burden whatsoever in this case. But didn't you have a DNA expert that testified in this case? And why didn't you ask him to test the sexual assault kid? Why didn't you ask him to test the Jeep DNA? But Rick, did the vandals know Mariah Wilson?
Objection, facts on evidence. We did ask, the state opposed, the court denied the testing of that DNA evidence.
Oh.
That is an absolutely flat-out incorrect statement. The court said that the defense could test the sexual assault kit whenever they wanted. And the defense didn't do it.
The district attorney opposed the testing.
That's
filed
not
such
Judge.
a motion.
I'm moving for the defense motion and the record of this happening in prior proceedings to be allowed for the jury to read it themselves.
Ladies and gentlemen, the evidence that has been considered, the attorney's arguments of this that it's not before you for this proceeding or for the proceeding. Just recognizing the attorney's arguments based on their statements on their recollections and the evidence as they have
Thank you. Thank you, Your Honor.
Wow.
There's no way that a prosecutor can stop a defense attorney expert from doing whatever they want with any kind of evidence. No way. There's no way that any judge would not allow that to happen. There's no evidence of that, and that's a flat-out lie.
I want to know now.
Gentlemen, why, and maybe Rick can tell us, but apparently the vandals who vandalized the home knew Mariah Wilson, had access to the black Jeep, and to Colin Strickland's laptop, and got away with it. And Rick, you seem to be blaming this on Colin Strickland, but then you say you don't know who did it.
Because you
Why
can't.
just stick to one simple, reasonable version of what happened? Who murdered Mariah Wilson? That the evidence all points in just one direction. And this case is all about what is reasonable, about common sense, and about the evidence. That's all I'm going to ask you to do. Be reasonable, use your common sense, and look at the evidence. Again, you heard the judge's charge. You have it with you. I urge you to read it. Reasonable doubt is not 100% certainty. It's not proof beyond all doubt. It's not proof beyond a shadow of doubt. As jurors, your job is to go in the back and examine all the evidence and to discuss the evidence. And if you have questions, to talk and discuss about it. It's called deliberation. Please do that. Take your time. And I think that once you do that, the evidence is going to point to you the one direction that you all know it should be pointing in. It's at the defendant. The defendant is responsible for doing this. Quickly, there was a lot of talk about Colin Strickland's laptop, iPads, vandalism, but there was no talk of how that was relevant to this. I think the evidence is pretty clear, uncontradicted, that Colin Strickland was not at the crime scene when this happened. His phone said he was in South Austin. All the evidence says he was in South Austin. So should they have taken his laptop and put it through a full examination? Sure. Why not? What relevance was that going to show to what happened here, ladies and gentlemen? He wasn't there. He was at home.
They can't make that argument, honestly. They don't know what was on the laptop. They don't know what little details were in the detective's notes that disappeared that could have twigged a question. They can't make an assertion that it was or was not relevant, that there would or would not be anything incriminating or exculpatory, because they don't know. They don't know what's on it.
Okay? It's simply what we call a red herring. It's please take your eyes off the ball, ladies and gentlemen. Don't look at the evidence.
And at the time that Detective Spittler gave Colin back his computer, they didn't have all this information. They didn't know. I'm not saying that calls it one way or the other. I'm saying the process it is really important.
Let's look at a laptop that wasn't tested. That's what they want you to do. All right? Same thing with the vandalism. What relevance is there? Did this person who committed the vandalism kill Mariah Wilson? Person somehow know Mariah Wilson all the way across town? Drive the defendant's Jeep? Have access to the defendant's gun? And by the way, apparently got away with it, so let me go vandalize the defendant's house so everybody will turn around and go, what happened? What relevance does that make? Does that make sense? Is there any reasonable explanation that makes sense?
But that's not what the defense is arguing. He's arguing something that the defense didn't actually argue. The purpose for the defense of bringing up all of this was to show that, look, this detective had tunnel vision. And you know what? He did. And he had confirmation bias. That's apparent. You know, you could argue misogyny here as well. Those were the arguments. The defense is saying, we don't know if something on there could have been helpful. For all they know, it could have made things worse for Kaitlin. That's the point. They don't know.
Sense that the defense attorney is urging you to go there. I want to talk to you quickly about the DNA evidence. Why is the DNA, well, let's talk about the DNA evidence in the body, okay? Specifically, defendant's DNA and Mo Wilson's body. Defense has been asking you to speculate, okay? Speculate as to how it got there. Because let's face facts, there's absolutely no evidence that you've heard in this court. No evidence that would let you render an opinion, again, based on the evidence, about how the defendant's DNA got there. They've asked questions about something called transfer, and doesn't transfer happen, and can't that exist, and so on and so forth. And what if she was wearing Colin Strickland's helmet and she had breathed in it at some point, and then somehow it got on Mariah Wilson, and Mariah Wilson got it on her hands, and so on and so forth.
People are assuming that transfer DNA would have come from Mo. But that doesn't make nearly as much sense, because it would have to be transferred repeatedly. Doesn't make nearly as much sense as the transferred DNA coming from Colin. You know, the person who lives with the accused. The person who would have tons of Kaitlin's DNA on him and on his belongings, etc., etc. It doesn't have to come from the helmet and this business of while breathing in it. I mean, I didn't hear the expert's testimony. It sounds a little bit far removed, but the obvious answer would be it comes from Colin. So,
No evidence whatsoever. But you heard from Dr. Califat. And Dr. Califat apparently was testifying when Mr. Kofer was not in the room. Because Dr. Califat, I thought, was very compelling. He told you that he has extensive experience in this activity level regarding transfer issue with DNA, something that the other two witnesses didn't tell you. And he described in detail how he would look at these scenarios, the possibilities of somebody's DNA ending up on a bike. And what I thought was very interesting is that he told you that the proposition that the defense wants you to buy off on, that somehow the defendant was wearing Colin Strickland's helmet at some point in the past, that we have no idea when or evidence that even happened, and that somehow she might have coughed in the helmet. And then Mariah Wilson got that DNA from the coughing on her face or on her hair. Second transfer, first from the defendant to the helmet, now from the helmet to the face or hair of Mariah Wilson. Then Mariah Wilson touches her face or hair, the third transfer, and then Mariah Wilson goes into the apartment and puts her hand on the bike and puts the defendant's DNA.
yeah.
That's a 4-time transfer. I don't even want to try to use the word that he explained to you what it was. But what I do remember is he said he'd never even heard of such a thing.
Yeah.
There was no studies that even indicated that. And what he told you, that if it was just a 3-level transfer, it would have been exceedingly unlikely. Okay?
The argument shouldn't be like a 4-time transfer. The argument is the transfer from Colin to the bike, not Mo.
Because as he told you, and all the DNA experts told you, that when it comes to transfer, you have to take everything into account.
Mm-hmm.
And what we know here is that Colin Strickland rode his motorcycle from South Austin to the dentist on a hot day in May with his helmet on. Got off, presumably took off his helmet because you're not going to go see your dentist with your helmet on. So he took it off, he parked his motorcycle, presumably walked to the dentist's office, opened doors, touched his hands on doors, presumably sat in a waiting area, presumably went into a dentist chair, put his hands on the dentist chair. So why didn't Colin Strickland get any of the defendant's DNA on? And if he did, why didn't he leave it all over? Why didn't he leave it in the dentist room? Why didn't he leave it on the door to dentist's office? Why didn't he leave it at a chair in the dentist room?
Did they go test the door at the dentist's office and test the dentist chair? How do they make that argument?
So then he left. He put his helmet on again on a hot day and drove all the way to East Austin in traffic. Okay? And again, the point of this is that Mr. Strickland, the owner of the helmet, the habitual using it, is gotta be, we've heard of sweating and leaving mounds of DNA in his own helmet. Okay? That's what evidence. That's real evidence, because we heard that from the stand. Okay? Mr. Strickland told you he was wearing that helmet and it was a hot day in there. Then Mariah Wilson.
They're making this argument. It's all sort of centered around the helmet. Maybe they're directing their focus this way on purpose. It wouldn't come from the helmet at all. And it wouldn't even come from Colin's hands. He went swimming. DNA on his hands in chlorine. I'm assuming it's chlorine. Maybe it wasn't. Maybe it's salt water. I don't know. Anyway, it would have come off if the DNA was just on his hands, if Kaitlin's DNA was on his hands. But his clothes would have had Kaitlin's DNA. His clothes, his jacket, his belongings that Kaitlin has also handled. The gun had both of their DNA on it.
Okay, Mariah Wilson rides the motorcycle all the way to Deep Eddy with the helmet on. So any DNA that survived the Colin Strickland encounter, okay, this super powerful defendant DNA that survived the whole Colin Strickland activity level, now is being subjected to Mariah Wilson. And Mariah Wilson wears it and takes off her helmet and goes swimming. So this super strong defendant DNA that presumably had to rub off on Mariah Wilson the first trip to Deep Eddy is now on Mariah Wilson. Mariah Wilson goes swimming. You heard the expert said it's going to get washed off. Then she's touching all kinds of things. She's at a table. She's eating food. And then she goes back and puts her helmet on and goes back. But somehow, in this strange world of possibilities, this super powerful defendant's DNA is still on the helmet. Okay? It's still there. And then, okay, if we assume that that's true, then we're subjected to this 4-time transfer that this expert has never, ever heard of.
It's not the helmet.
They want you to contort yourself and to twist yourselves and to bend yourselves into an unreasonable position in an attempt to make you to keep your eyes off the evidence. What I heard from the DNA expert is that the simplest, logical, most reasonable explanation for the DNA, for the defendant's DNA to be on this bike is this. As much as this hurt Rick's feelings, and thrown it in. Simplest, most logical reason.
There is another explanation that is not as convoluted as this other thing that he's describing. And it is also a simple explanation.
And I know Rick likes to say, well, why didn't she just carry it like this? But use your common sense. I think most people, even Colin Strickland's people, carry it. And you heard the defendant has experience with bikes. So that's the most logical way I would assume she would be carrying the bike.
I would assume.
And you know what is most impressive about this whole DNA thing before I move on? That not one bit of Colin Strickland DNA is on this bike. Because we've already talked about that Colin Strickland was the person who was wearing that helmet most of all. He wore it from South Austin to Northwest Austin. He wore it, he's sweating. Then we heard that Mariah Wilson was in close contact with him riding that bike. Her arms and her legs around him while they were riding that motorcycle. So when Mariah Wilson somehow magically transfers this super powerful defendant DNA onto this bike, why is there not one bit, why is there not one bit of Colin Strickland DNA? And you know the reason, ladies and gentlemen. You all know what the reason is. It's because Mariah Wilson didn't touch that. The defendant touched the bike after she exited. She took the bike out and she threw it outside. You heard from Steve Aston. Okay, I submit to you, Steve Aston was a careful and deliberate examiner here. Okay, he told you exactly what his results were. He showed you the results, and he told you that his results, his conclusions were not to the exception of every single firearm in the world. Okay, he told you that was just something that he can't testify, even though the defendant, defense attorneys gigged him into saying, but you're bucking the AFTE methods, and showed him on his laptop and said, but AFTE says you need to say that it's beyond the other gun. It's beyond any other gun in the world. And he said, no, that's not the way I do it. That's the type of guy he was. And I don't want you to remember that this is the same guy that did say all 3 shell casings came from her gun. But out of the 3 projectiles, found one inconclusive. So I submit to you that Mr. Aston is not on any kind of a vendetta or trying to nail somebody or anything like that. Because he wouldn't have testified in that way if that was in fact his agenda. I would also remind you that a separate analyst reviews all this and comes to the same conclusion. So it's not just Mr. Aston we're talking about. Now Mr. Tobin, very smart man, who I would submit also has a job that depends exactly on the type of testimony that you saw here, goes around the country testifying and getting paid to that. He offered a lot of hyper-technical information. But what I took from this, and your recollection, talk to yourselves, I'm sure some of you guys have good notes. He said that firearms examination was one of the 3 most effective investigation tools that he knew. One of the 3 top investigative tools that he used. That's from the man that apparently has nothing good to say about this field. But he admits that it's one of the top 3 investigating tools that he knows about. He didn't disagree with Mr. Aston's conclusions. Again, talk to each other, look at your notes. He said, I can't disagree with what his conclusions are. His major issue, and I asked him that, was with the issue of uniqueness, which what the defense attorney is calling individualization and had up here on the screen. Uniqueness. I don't think they should be saying that this is the only gun that could have done it. That's really what he was saying. I don't think they should say that. I don't disagree with his conclusions that this could have come from this gun. I just don't like them saying it's the only gun in the world that could have done it. But of interest was that when Mr. Tobin was in the FBI, apparently he did that very same thing. We talked about that article he wrote where he was able to take a piece of plastic and link it to the machine that made it. Isn't that what we're talking about? Linking bullets and shell casings to the machine, the gun that made it? He had no problems when he was with the FBI doing that. And he specifically told you, when I asked him, he used the word uniqueness in his article. Unique and uniqueness. That was Mr. Tobin when he was the FBI. What happened? I don't know. You get paid, you become a defense attorney. Look, I'm not going to question why or what the change of whatever took place in Mr. Tobin's mind. That's beyond me. I just think that it's something that was interesting and you guys should consider. I would also point out that after a lot of pushing and shoving, it turns out that a lot of the most prominent scientists in the world, in the United States, disagree with what Mr. Tobin was saying. And you heard that. And we went from talking about somebody called Bruce Bedoli, Dr. Bruce Bedoli, who said, I may have heard of it, to I got his report on my computer. If you give me a minute, I'll look for it. Okay? But this man, Bruce Bedoli, one of the most prominent DNA scientists in the world, I think that even the defense attorney expert was asked at one point, it might have slipped in you, if they knew who Bruce Bedoli is, and he said, "Oh, of course I do." Right? But those are the type of people that disagree with Mr. Tobin. So all I'm saying is, look, Mr. Tobin's entitled to his opinion, but don't accept it like it's gospel, like he wanted you to take it. There's equally as powerful and as smart and prominent people who disagree with him on this very issue. Mm-hmm. Okay? And as you heard, this subject it's taught all over the United States and all over the world, and people testify to this all over the country and probably all over. That's all. I do want to mention of interest how all this evidence seems to be interlocked, and every time you turn around and try to go, well, maybe I'll give her another thought, maybe it wasn't her, maybe or something, you run into the door and it has Kaitlin Armstrong's face. And you know what that was? The one item that just jumped up to me? We got to go back to January 12th of 2022, all right? Months before the killing. Defendants at the range in Austin, Texas, learning how to shoot her gun. All right, we've seen her on video. She apparently can hit a target at least 20 or so feet away, which, by the way, is more than enough of a distance to kill Mariah Wilson. And she buys a box of ammunition. Now, using your common sense, we all know that there's probably hundreds, if not thousands, of different companies or boxes of ammunition. She picked the one box that had the same shell casings as that were recovered at the crime scene. The box of ammunition that she bought, she had the pick of the litter. She could pick any ammunition she wanted. She bought a box of Ammo Inc. ammunition that we all know.
Maybe she picked that ammunition because it looked familiar. So maybe she looked and said, oh, that looks like the right one. This is a stretch too. There's enough that's against her that's really bad that they don't need to do this.
No. Now owns Jaeger. And that commonly when you open Ammo Inc. boxes of ammunition, they're full of Jaeger bullets. Or head stamps on Jaegerman's head stamps on the ammunition. And again, Jaegerman is what was found at the crime scene. I mean, you can't make this up. Every time you turn around, it's pointing at her. Detectives told you this was personal. Okay, this is from detectives at APD, and they explained the reasons. But you heard from the medical examiner. 2 shots to the head, 1 behind the ear, 1 in the face. And then another shot while the person was laying on the floor, through the chest, through the heart. Okay? Again, common sense and logic. If you're some unknown person who's not there for a personal reason, you just shot somebody twice in the head. Are you running? Are you getting the heck out of there? Are you taking additional time, crucial time for you to get away? Thank you. To walk up to somebody on the floor, bloody, and put one more in, right in the heart. And by the way, nothing's taken from this apartment. Nothing's kicked over. Nothing's pushed down. Nothing's except for what turns out to be really this is Mariah Wilson, isn't it? Isn't that what the defendant sees here? That's Mariah Wilson. Mariah Wilson, the up-and-coming superstar cyclist, who my boyfriend is constantly talking to, who also is a superstar cyclist, and that I can never be. And that apparently that's something I will never be able to bridge, that connection between my boyfriend and this young 24-year-old up-and-coming superstar. This is Mariah Wilson. She knew that. She took the one thing that she hadn't done already. She already killed her. I'm taking this and I'm throwing out this. Just kind of an extra take that. she's viewing Mariah Wilson's profile and activity on Strava on May the 9th, on May the 10th, and on May the 11th. She's not a fan. She's not a fangirl of Mariah Wilson. We heard that from the people that know her best, her friends, and Colin Wilson. Why is she looking up Mariah Wilson 9, 10, 11? Why is she looking at Mariah Wilson 5 or 10 minutes after the last text exchange between Colin Strickland and Mariah Wilson, making plans, formalizing plans to go out? Why? Why is she searching through the profile to the 3rd level so she can see in every excruciating detail where Mariah Wilson was when she started and finished her life? And if we go back a little bit further, on May the 2nd, the day that she decides to suddenly fly out, or the decision is made to fly out to meet Colin Strickland in Arizona, why is she viewing Mariah Wilson's Instagram account? Why does she have this note in her phone, 1704 Maple, that we introduced the map about? And then deletes it. Why? Why, Rick? Why does she fly to Costa Rica? Why does she use her sister's passport? Why doesn't she use her own name? Why doesn't she use her own passport if this was just some innocent frolic to Costa Rica because that's what I can do? Why does she use fake names when she's in Costa Rica? Why does she desperately start looking for plastic surgery in Costa Rica? Okay? Why? Allison Page, Ari Roberts, who knows what else there is? These are all indications of guilt, ladies and gentlemen. Can we forget the search for pineapple juice and what it does to your fingerprints? This is somebody that's trying to hide themselves. They fled the country under a false name and not their passport, get to another foreign country, use fake names, and change their appearance. This isn't somebody on a frolic. This is somebody who's a fugitive and desperately trying to get away with it. This is a person that searched in Costa Rica articles that you saw that said Kaitlin, some and substance, Kaitlin Armstrong's wanted for murder in Austin, Texas. So she knew it. Mm-hmm. She knew it. That interview on May the 12th that they urge you to believe is just, well, common sense, and none of us would cooperate with the police after what they just did to us. I mean, of course not. The other side of the coin is, ladies and gentlemen, you have a police detective telling you, I want to talk to you about a murder of someone you know. And I have your boyfriend in the next room telling me you have issues with this person. Huh? Sounds suspicious, or doesn't look good, or I'm sure there's another explanation. Look at the video. The detective wasn't pressuring her. I'm sure there's another explanation. Can you tell him? Your Jeep's there. She's dead. You seem to have a beef with her, and your Jeep's there. I don't want to talk to you. I gotta go. Because you brought me on a Class B misdemeanor. Common sense. What would you do in that situation? That's all
He's mischaracterizing that a little bit.
I'm asking. Would you say, nah, Colin Strickland or this mysterious person that we still don't know was driving my Jeep, or, I was running along my Jeep from South Austin to downtown while somebody else was driving my Jeep? Because apparently that's what they want you to believe. That somehow, I don't know why that matters, that the phone isn't in the Jeep, but they sure were next to each other for the whole, if they weren't inside, then they were sure right next to each other the whole time. And a simple explanation is we heard over and over again that GPS is more precise than the phone. Right? So if the phone is 20 feet away, you know what? GPS is more. And if she chose to be in some parking lot with the Jeep running for 15 minutes, what has that got to do about why she killed Mariah Wilson? Keep your eye on the ball. That's all we're asking. Keep your eye on the evidence. All of these questions about MacBooks and sexual assault kits and why didn't they test the Jeep? Oh my God, what happened if somebody went into your car and took DNA? How many people's DNA do you think they would find? Every person that sat or was a passenger in your Jeep probably left DNA in there. And how does that move the ball here? Keep your eye on the ball. Okay? That's all I'm asking. And if you do, ladies and gentlemen, if you look at all of the evidence, look at it with common sense, logic, let the evidence take you where it's pointing. That's all I'm asking. You're going to find that the evidence is right there. That's the only place the evidence is pointing. From the Jag bullets to her running away 3 weeks ago before trial or what. Beyond a reasonable doubt. Executed Mariah Wilson in her friend's apartment. And then gave her one more for good luck. Thank you. This has been a long and sometimes tedious process. I know you guys are all paying close attention to what's going on. I really appreciate it. We all appreciate it. Do the right thing.
Your Honor, defense joins the state in their motion to release the sealed defense motion for forensic testing of evidence rape kit filed on October 12th, heard in a hearing before this court on October 13th. A readback of that transcript, including the state's position and the sealed order denying that motion.
Pardon me. Before you don't take one, maybe you should go take me first. You're going to recess to deliberate the vote.
He just got up knowing that this is being live streamed or televised and talked about what was in the contents of a sealed order and did so in front of the jury.